ECS-10 from 2018, Energy Community Secretariat against Bosnia and Herzegovina, concerning a state aid decision of the Council of Bosnia and Herzegovina. Now, at the beginning, I would again ask you to mute your microphones, please. And at the beginning, you could see also the members of the advisory committee, but the members of the advisory committee will now also switch off the cameras in order to have a good connection with all the participants. Now, what I'm doing now is, first of all, I will ask to switch on the camera of the representatives of the Energy Community Secretariat. I have seen them before. It's Mr. Buschle and Ms. Richter. Can you switch on your camera, please, and just say a few words so that we can check whether everything is working?
Yes, hello and good morning, everybody. You can hear us fine.
That's very good. Thank you, Mr. Buschle. Now I'm asking the representatives of the contracting party of Bosnia and Herzegovina. We received an information from the Ministry of Bosnia and Herzegovina stating that on behalf of Bosnia and Herzegovina, and let me check this whether I understood it in the right way, on behalf of Bosnia and Herzegovina, there will be Mr. Gecić and Mr. Ristic. Is that right? Mr. Gecić, I can see you.
Hello, good morning. Can you hear me as well?
Yes, that's perfectly working. Thank you.
Okay, thank you very much for your question. Good morning, Honorable President, members of the Advisory Committee and dear participants. And just to briefly respond to your question, yes, that is correct. In addition to that, that also entails Ms. Adina Claici from Copenhagen Economics, who should be also with us. Yeah, there she is.
Good morning, yes.
Yes, we can see and also hear Ms. Claici. Just at the beginning, I can say that in case we have questions to the representatives from Auxerre or Copenhagen, we will ask questions, but we mainly ask the representatives like Mr. Gecić and also Mr. Buschle and Ms. Richter to represent the parties. Thank you.
Thank you.
Mr. President, I may already at this stage make a request. We would request also Bosnia and Herzegovina as a party to the case here to provide written power of attorney to Mr. Gecić. We have seen that Mr. Gecić also, when he was appointed to plead here, was appointed as a lawyer representing Elektroprivreda. And that should be clarified because we don't find it acceptable that the beneficiary to the aid here, which forms subject matter of this case, which did not avail itself of the possibility to intervene in the case as it is envisaged in our dispute settlement rules, now to come in representing the party to the case. It may be that Mr. Gecić indeed has that power of attorney, but we would request that a written signed power of attorney is taken to the file of this case, and evidently we can do the same as well. Thank you.
Just a second, Mr. Gecić. We received, Mr. Buschle, we received from the relevant Ministry of Bosnia and Herzegovina an information about the speakers on behalf in Bosnia and Herzegovina. And among these, the list was Mr. Gecić, but it was said in this letter, Mr. Gecić for Elektroprivreda. So this is how I was asking at the beginning of this hearing whether Mr. Gecić has the power of attorney also to represent Bosnia and Herzegovina, but maybe Mr. Gecić, could you please also clarify this? Thank you.
Of course, thank you very much, Honorable President. I mean, I think that the good Mr. Buschle hasn't been really following our emails. We've attached a authorization that was signed by 2 ministers in Bosnia, And also a week, well, 11 days ago, on November 27th, we've directed the Secretariat to His Excellency Assistant Minister Softic for any clarification in writing if needed. I presume Assistant Minister Softic was thought to also join us. I'm just looking now, and I'm not sure whether that's the case. But if not,
but it's clarified, so you can speak. You say you have the power of attorney to speak on behalf of the contracting. Okay, thank you. Now, before we start, please, I would like to ask you again to switch off your microphones, and also, please, for those who are not speaking, also your camera. I see, sorry to name Mr. Gecić and Mr. Gcić, there is still the microphone open, so maybe you can check again. Thank you so much. Now we'll start, and we will start now with the representative of the Energy Community Secretariat. I want to mention one thing. On the 8th of December, so yesterday, we received another letter from the Energy Community Secretariat. Since we received this letter after the 27th of November, we will not take into consideration what was said in this letter. But if you want to give us information right now about the content of the letter, this is possible. But regarding this letter from yesterday, we will not take it into consideration unless you are now also giving information about this letter. This is what the public hearing is now for. The aim of the public hearing is, of course, to give all information to the advisory committee. Now, I would ask now Mr. Gecić. Yes.
Thank you, Honorable President. On that point, we would need to object, as we did in our email of yesterday, and frankly, strongly object, because Bosnia has very kindly asked, before even trying to provide any comments, and you and your decision on December 1st have rejected this on arguments of equality of arms. On the other hand, the Secretariat, knowing this, very wantonly, on the very last day, sent this out. We haven't heard any decision from the advisory committee the entire day yesterday and until now. So we had no choice but to actually work on this document yesterday, which hampered our defense. And I repeat respectfully our request for postponement for the equal amount of days as the good Secretariat exhausted in preparing this document, which is 11 calendar days. Thank you.
Mr. President, may I reply to this?
Mr. Buschle.
Thanks. And this is not just for the record part of the pleading, but I think we should, at this point already, get one thing very clear. These exchanges, all the exchanges, in fact, that happened after 26th of August 2020, do not form part of the case file. And that's why we agree with the President's announcement that the letter of yesterday would not be taken into account. It was not meant to be taken into account as part of the case file. It was meant because we were asked before to share our correspondence and the outcome of our consultancy contract that we have with Oxera, and we duly did. We didn't want to be accused of sitting on any document and not sharing immediately. However, when it comes to what forms part of the case file or what forms part of this case and the subject matter to a decision by the Ministerial Council and also opinion of the advisory committee, it is to be made very, very clear that we are in a formal procedure here which has a written part and then a part in front of the Ministerial Council. The written part expired with the recent request sent by the Secretariat and the party concerned, Bosnia and Herzegovina, which didn't avail itself of the possibility of sending a reply. The deadline was 26th of August 2020. All other submissions, be that Copenhagen economic reports, be that Oxera reports, be that the submissions that Mr. Gecić, extensive submissions, bringing new arguments that Mr. Gecić made sometime towards the end of November, they do not form part of the subject matter of that case. And that's very important to underline, because otherwise we would step out of the procedural rules of that case. So I do absolutely agree. These economic reports that have been shared are not needed, nor do they form part of the case file. They are not needed to find a decision in this case, as we will argue later. And even less so is their sending, which we did as a matter of courtesy yesterday, any reason to postpone a hearing again that I recall Bosnia and Herzegovina has asked for and keeps on trying to postpone. I think there is no justification whatsoever for that. Thank you.
Okay, Mr. Gecić, a last word on this procedural issue before we continue, and then we will continue with the Energy Community Secretariat. Mr. Gecić.
Thank you very much, Honorable President. First of all, I mean, everything that we heard now from the Secretariat is something that we heard 2 months ago, and it was overruled by your own decision. And so I think, frankly, that this is also a show of disrespect for the decisions of the Advisory Committee of October 9th. Moreover, as a taxpayer and a national of the energy community, I don't understand why the Secretariat would spend thousands of euros of our own money for a report that they don't need. That's how much they paid for the Oxera report that they contracted only at the end of September. But more importantly, this is completely outside of the scope of our request. Our request is that we are respected and granted equality of arms, which means that if the Secretariat exhausted 11 days and probably spent also more taxpayers' money to prepare a response and filed it in direct disregard of your own decision, Honorable President, of December 1st, that no one can file anything more after November 27th, we should be allowed enough time, which is 11 calendar days, to get acquainted with this and be ready for the hearing. And frankly, we would kindly ask a reasoned decision by the Advisory Committee if this is a rejection of our request. Thank you.
As I said before, this what was brought in by the Secretariat, this letter from the 8th of December is not taken into consideration by the Advisory Committee. So therefore, both parties had the possibility to hand in their positions until the deadline of the 27th of November, and therefore we can proceed with this public hearing. Now, I would now ask the Energy Community Secretariat. You have 15 minutes maximum, and I would like to invite the Energy Community Secretariat to give us their position.
Thank you very much, Mr. President, honorable members of the Advisory Committee, distinguished colleagues from Bosnia and Herzegovina. We're happy to continue our pleading. And I would just like briefly to reply to Mr. Gecić. Your taxpayers' concern is taken note of. I think a taxpayer's concern would have been more in place when looking into this case that we are actually looking now on, and that's how public money is spent on building a coal-fired power plant in Bosnia and Herzegovina. This has been subject, as we have just been discussing, also to economic reports, and I think the point that I was making before is crucial here for this case, and also for the right understanding of this case. These two economic reports, Copenhagen and Oxera, were commissioned. First there was Copenhagen, then there was Oxera, and the one was needed to understand the first one. Both, however, were commissioned post factum. So after the State Aid Council handed down its decision, which is subject to review, which was subject to review by the Secretariat, which is subject to review by the Ministerial Council, and hence also by the Advisory Committee. I am sure that you, Mr. Gecić, will try to make us believe after that as well that these reports are essential to the case, and that the Secretariat should also already have been carrying out such a report and assessment, an in-depth economic assessment especially on the market investor test when it was reviewing the State Aid Council's decision. Well, that's actually not the case, because such a thinking and such a framing of this case would completely reverse the roles and responsibilities in our case here. Mr. Gecić, your argumentation, respectfully, is based on a wrong analogy, and it confuses the role of the Secretariat with that of DG Competition. Under the Energy Community Treaty, there is no supranational state aid enforcer. It's not the Secretariat, it's the national authority which is in charge of implementing European state aid law. So that's the way how the Energy Community Treaty is conceived and phrased. And it is the State Aid Council of Bosnia and Herzegovina which has to decide whether or not a state guarantee does constitute state aid. And then it's for that authority, the State Aid Council, to carry out all the economic tests needed, including a market investor test, in a manner that lives up to the standards set by the European authorities and courts. The Secretariat's task in an infringement procedure, and the same goes for the Ministerial Council and the same goes for the Advisory Committee, is to verify whether the State Aid Council discharged with its task properly. Unlike DG Competition, to whom you constantly refer, we are called upon to review and not to replace the findings of the State Aid Council. Whether the State Aid Council indeed, in this particular case, has discharged with its duties in a proper manner is a legal question, and it can be answered legally, as we will show in a minute. This brings me to a second point that I would like to make, and I will be very brief here. It's a second point which actually is included in Mr. Gecic's so-called response, a response that came after the written procedure of this case has been closed, and it concerns or it alleges lack of jurisdiction. The reason why I can be short about this is because the Honorable Advisory Committee already had the opportunity to express itself on that very argument. The Energy Community Legal Order and Energy Community Law, as defined by Article 1 of the Dispute Resolution Procedures, is autonomous and independent of bilateral agreements concluded between the EU and Bosnia and Herzegovina. This follows from a provision, Article 103 of the Energy Community Treaty, which requires that treaty, the Energy Community Treaty, including Article 18, does not affect the commitments made in bilateral stabilization. Mr. Gecić may not have read this, but the Advisory Committee already in an opinion given in case ECS-10 found that Article 103 does not establish a relation of primacy of bilateral agreements over the Energy Community Treaty. But, and here I quote, it allows contracting parties to enter into commitments which go beyond the acquis of the energy community. The mere fact of ongoing accession negotiations is not sufficient to suspend all application of the existing law. And the Advisory Committee in that case also deemed that Serbia, which was the contracting party concerned in that case, should have explained which, again a quote, which specific commitment of its accession negotiations would authorize a derogation from the acquis communautaire. We respectfully submit that this test is not satisfied in the case at hand. We can simply not see how the correct implementation and application of Article 18 of the treaty creates a conflict with the provision of the Stabilization and Association Agreement, which aims at Bosnia and Herzegovina achieving precisely the same. And now I will hand over for a discussion on the substance of the case to my colleague, Dr. Richter.
Thank you. So we would like to bring the discussion of this case back to what it is about, namely the question whether the State Aid Council decision is correct or not. The subject matter of the case is whether the State Aid Council in its decision erred in law when finding that the guarantee for the Tuzla-7 project does not constitute state aid and hence violated Article 18, the state aid prohibition. The State Aid Council's decision bases its findings on the 4 conditions of the European Commission's notice on state aid in the form of guarantees, which is indeed the yardstick for this case. The notice lays down the principles for the correct interpretation of Article 87 of the EC Treaty and its application to state guarantees, which is also relevant in our case because of Article 18, paragraph 2 of the treaty. In particular, it sets out a number of conditions in order to facilitate the assessment of whether the market economy investor principle is fulfilled for a given guarantee. Mr. Gecić repeatedly stresses the importance of undertaking this market economy operator test. That is what is done and simplified by the Commission in stipulating these 4 conditions. The fulfillment of these 4 conditions would mean that a guarantee does not constitute state aid. The notice explicitly says that the fulfillment of all of the following conditions will be sufficient to rule out the presence of state aid. I repeat, only the fulfillment of all of the conditions rules out the presence of state aid. Non-fulfillment of a single one of them excludes the possibility to rely on the notice to reject the presence of state aid. The State Aid Council assumes in its decision that all 4 conditions are fulfilled, and this is why we addressed each one of them in the reasoned request. But I repeat again, if only one of the 4 conditions is not fulfilled, a subsidy is ejected from the safe harbor created by the Commission notice. I would like to deviate from the order of the conditions in the Commission notice and start with the 2nd and the 3rd condition because they're already on the basis of the wording, the condition is not fulfilled. I start with the 2nd condition. The extent of the guarantee can be properly measured. The guarantee at issue covers additional costs, namely any other amount agreed. This is commitment fees, management fees, exposure fee, increased costs due to change of law, transaction expenses, amendment costs, enforcement costs, etc. There is no limit for these costs. It does not matter whether they're only marginal, and by the way, I doubt this because enforcement costs and legal fees can be tremendously high, or have not materialized in the past. The notice requires that there is a maximum and there is no maximum. The condition is not fulfilled, and therefore the State Aid Council incorrectly concluded that based on the Commission notice, there is no state aid. The 3rd condition, 80% limitation to cover by the guarantee. The guarantee covers 100% of the loan. This is admitted by Bosnia and Herzegovina. This is confirmed by the State Aid Council. The yardstick is the financial obligation, the loan, not the whole transaction. The wording is very clear on this. The reason is to ensure that the lender has enough incentive to properly assess the risk. This is precisely not the case here. The condition is not fulfilled, and therefore the State Aid Council incorrectly concluded that based on the Commission's notice, there's no state aid. Interestingly, the argument of the exception to the 80% threshold is not taken up after the State Aid Council's decision anymore. However, because the subject matter here is the State Aid Council's decision, we will also address the non-applicability of the exception to the threshold. This would require, first, that EPBH's sole activity is constituted by a properly entrusted service of general economic interest. This is not the case because there is no proper entrustment in the sense of the Electricity Directive, which requires that such a service is provided in the general economic interest, compliant with the principle of proportionality, limited in time, clearly defined, transparent, non-discriminatory, and verifiable. Second, EPBH would not have to provide more than one service of general economic interest and no economic activities. This is also not the case. The State Aid Council alleges that there are more than one services of general economic interest, and it also admits that EPBH is engaged in activities which are clearly market-based, such as generation, supply, electricity trade, import and export. And finally, the guarantee must also have been provided by the same authority that entrusted the service of general economic interest. This is not the case. The guarantee has been provided by the Federation's Ministry of Finance, which never entrusted EPBH with any of the alleged services of general economic interest. The first condition of the Commission notice is whether the borrower is in financial difficulties or not. The criteria relevant here are the ones of the rescuing and restructuring guidelines. However, the Stated Council in its decision did not properly assess the criteria it assessed because the data it relied on do not match the consolidated financial statements, and the auditor's critical comments about those statements were not taken into account. And second, the Stated Council did not assess all criteria. The guidelines provide for 3 criteria. The Stated Council only assessed 1, the ratios. Although the answer to the remaining 2 criteria could possibly be inferred from the facts lined out in the introduction, the Stated Council failed to assess them and conclude on them. Please note that the Secretariat did not claim that EPBH was in fact in financial difficulty. We were not in a position to say so due to the lack of reliable data. But what we were in a position to say is that the Stated Council did not assess all conditions, and the ones it assessed, it did not do properly. Therefore, the decision is flawed. And finally, the 4th condition, which requires a market-oriented price to be paid for the guarantee. I go back to the Stated Council's decision, the subject matter of the case. The Stated Council in its decision uses as a benchmark the EBRD loan. One loan. Copenhagen economics says no firm conclusion can be drawn from a single indicator. We agree, but this has happened in the Stated Council's decision. Furthermore, we consider that this loan is an inappropriate benchmark because of the main reasons that the EBRD loan is considerably smaller. The loan amount is 17.5 times smaller, 35 million compared to 640 million to be covered. And the lender, EBRD, is very different in its nature. It is unimaginable that EBRD would lend such a high amount of money for a coal project at the same interest rate to a small hydro rehabilitation project for a shorter maturity. Therefore, the Energy Community Secretariat argued that the Stated Council's assessment of the market price is flawed and therefore does not comply with the Energy Community Law. To conclude and sum up our submission, we submit to the Stated Council's findings in their decision that on the basis of the 4 conditions of the Commission notice, the guarantee does not constitute state aid is flawed. The Stated Council did not correctly assess the question whether EPBH is in financial difficulties, and contrary to the findings of the Stated Council's finding, the guarantee is not provided for a fixed amount. The guarantee does cover more than 80% of the outstanding financial obligation, and the exception does not apply. And finally, the Stated Council did not correctly assess whether the guarantee was remunerated at market price level. Therefore, the Stated Council incorrectly concluded that on the basis of the Commission notice, the guarantee does not constitute state aid. Thank you.
Now I call on the representative of Bosnia and Herzegovina, Mr. Gecić. Mr. Gecić, you have 15 minutes.
Thank you. Can you just bear with me because we would like to share the slides just to see whether this works?
Yes, you can share the slides and it is working.
Okay, fantastic. Okay.
15 minutes, Mr. Gecić, please.
So I won't reflect on this too much again, but this is, as you know, an excerpt from the Oxera contract that the Secretariat signed back in September 29th. And actually, with all of these statements by the Secretariat, we fully agree. And we believe that this is the role of the Secretariat, although we also agree with the Secretariat that the role is quite ambiguous in this whole matter. We would move, as Bosnia and Herzegovina, for the Advisory Committee to suggest to the Ministerial Council to dismiss the reasoned request. For the first point is, of course, that we believe that the Secretariat in this specific case lacks jurisdiction and, more importantly, misapplied the governing law. On top of that, we believe that the Secretariat had the duty to perform an MEOP, especially if they try to claim that the decision of the local authority is flawed. And on this point, I need to reflect on what we just heard. I mean, I have a big question in the sense that I don't understand what's actually the Secretariat's opposition now to the decision of the local authority. They don't agree with the reasoning. because otherwise, I mean, the outcome, even if the reasoning wasn't perfect enough for the Secretariat's expectations, the outcome is exactly the same as we will show now. Now to proceed, when it comes to EU association law, we need to make a couple of points. First of all, this is not a bilateral treaty, the association agreement. It is a mixed treaty with all member states of the Union and the Union itself under established case law. So we're talking about more than 20 cases in a span of 40 years. Association agreements with prospective members to the Union have direct effect, have primacy, and are equal to the treaty itself, from the Hageman ruling all the way onwards. If we look at the association agreement of Bosnia, especially Article 71, it will be absolutely clear that this case was never intended to be reviewed by the Secretariat. When we talk about the tests that the good Mr. Buschle mentioned in the case of Serbia, frankly, we're not privy to what happened in that case, but what we can say that in this case, it's absolutely relevant that the association agreement and EU association law is directly applied. It's a ratified treaty under Union law. In that sense, Bosnia was given an automatic 6-year assisted area exemption as of the coming into force of the association agreement. This was completely disregarded by the Secretariat. Homogeneity does not apply in this case. Quite the opposite. The association agreement has an explicit and mandatory clause on gradual approximation, which is, by the way, the only constitutional way to introduce and transpose the acquis into national law. Convergence of EU-governed and state aid cases is extremely important, because the very smart system that was put in place under the association agreement, where the DG Comp has supervisory powers together with the national enforcer, and this is the only case, by the way, where you have national enforcers of state aid law, otherwise it's centralized in Brussels, was exactly intended to work in this, in this specific case. When it comes to even the existence of the national enforcer, there's not a single word in the Energy Community Treaty. It was never intended to do so, and theoretically it wouldn't be even possible to implement. The whole establishment of the national enforcer in state aid cases was done under the association agreement, as you can see in these two provisions, including the mechanism for exchange of information. None of this exists under the ECT. On top of that, I'm again referring to the assisted areas argument. This was completely disregarded by the Secretariat. There is ample case law where guarantees can go up to 100% if you're on assisted area A. And that's exactly what Bosnia is and was at the time of this decision. On top of that, and this is extremely important, there's no automatic application of the acquis. One needs to actually apply local law and approximate it with the acquis. And this is actually something that even members of the advisory committee agree on. I referred to an article by Ms. Josephine Coleman back in 2009, and as you can see, and we emphasized a couple of points, members of the energy community officials explicitly state that homogeneity does not apply in the treaty of the energy community, unlike the EEA. Now to go back to more substantive issues, and that's the question of the MEOE. I think we all agree that this is a key issue, that when the European Commission does its cases with acceding countries, pre-accession cases, it always does the MEOP test. We've done an ample amount of these cases in Brussels, and I can tell you that the practice is that it's always done. Moreover, the ECJ case law says that the methodology must be objective, verifiable, and based on reliable data. When it comes to the MEOP test, we refer also to the EDF judgment by the ECJ, where you can see what is the duty and what everything needs to be taken into account if one wants to challenge, especially like this, challenge an already existing decision. one needs to show manifestly, that's the standard, the threshold of proof, manifestly that the local authority was wrong. If we read everything that Doxera said, including even yesterday, there's no show of manifest error. Quite the contrary. We hold that Doxera's analysis is flawed. And since in this case, we've seen unprecedented breaches of due process, and everybody was allowed essentially to submit, especially the Secretariat, whatever they wanted, whenever they wanted, we also, and before I get to that, I do apologize. We have an additional slide, and this is the 4 safe harbor conditions. Why they're called safe harbor conditions under the acquis is because it's not per se that once you don't tick this box, it's automatically state aid. It just means that when you're outside of the safe harbor, then you need to do an economic assessment, what we've been saying the whole time. And now to move to something that we received from a highly reputable Austrian bank, which was awarded last year as the top bank in the Bosnian market. To your left is a conveniency translation. To your right is a co-signed certificate issued by the bank that says that the guarantee was issued on market terms. I'll give you a couple of seconds just so that you can see this. The emphasis is in bold to your left side of the slide. To your right side is the statement co-signed by the risk managers at the bank. Therefore, we strongly believe that the Secretariat got the whole case completely wrong, and except in their wish maybe to change the reasoning of the decision of the local authority, this is absolutely, and I underline absolutely, the same outcome. The SGIE exception, since homogeneity does not apply, is satisfied, and we can strongly and unequivocally say that this case does not entail state aid. On this point, I will call Ms. Adina Claici to continue our presentation. Thank you.
Now, Mr. Gecić, I would like to ask you if there is anything to add. I would like to ask you, since you are speaking on behalf of Bosnia and Herzegovina, if we have questions, and I will now ask the rapporteur of this case, if we have technical questions and economical questions, we are happy to bring in the experts from Copenhagen and also from Auxerre. But if you have anything to say right now, I would like to ask you to continue, Mr. Gecić, and then I will hand over to the rapporteur in this case, whether he has questions, including questions to Ms. Claici. Do you have anything more to say, Mr. Gecić?
Yes, I do. Honorable President, thank you very much, but we need to kindly disagree with this. As you know, the ministry has appointed Ms. Adina as a speaker. In addition to myself, you have 3 names. We have His Excellency Assistant Minister Softic with us, if you need this to be confirmed once again. But Ms. Adina Claici is a speaker in equal capacity to myself, and I don't see a reason under any law, including especially the acquis, that she would be prohibited of speaking.
So Ms. Claici was named by the contracting party as a speaker?
Yes.
Okay, then Ms. Claici, go ahead, but you know that in total you have 15 minutes, so you have 6 minutes left.
Yes, thank you very much. I hope you can hear me, and I will do my best to keep the time.
We can perfectly hear you, and we also can see your slides, but if you can make them bigger, it
yes.
would be better. Thanks.
Yes, thank you. And the first thing I would like to say that I respectfully disagree with what the Secretariat had said at the beginning, that our report has no value because it has commissioned ex post or post factum. I wanted to state that in all the commission cases, they apply the notion for state aid. that the European Commission has published that says that there is no problem to bring post factum evidence to the extent that it uses contemporaneous evidence. So that's what we exactly did. We put ourselves in the shoes of the investor at that time, and then we only used information available at that time. So for this reason, I strongly argue that this is a valid, our evidence is valid, even if it was produced by us this year. I would just briefly want to provide the context. So as the Secretariat correctly mentioned, these are the conditions to show aid in the case of the guarantee. Since 3 of the conditions that we put forward in our report this summer have either not been contested or been agreed by Oxira, I will just briefly refer to the market-oriented price that is paid for the guarantee in this few minutes that I have. So in the first place, I wanted to say that this case is not a standard Commission case. We are talking about a very specific entity in a country that is not even in the EU. So therefore, benchmarking is with finding a perfect benchmark for a market-oriented price is basically impossible. What we did find and what Mr. Gecić put forward is the best possible, closest possible market indication of this, which is the statement of a bank, of the market operator itself, stating that the conditions of the guarantee are in line with market prices. This, as you will see in the Commission notice, can be the most directly related to the market evidence that we have. Moreover, leaving this aside, any other benchmark is not sufficient in itself because it's imperfect to show the existence of aid. Therefore, what we have done in our report in summer, and which Oxira commented, we found a range of benchmarking, giving us a range of plausible values that indicated that the price of the guarantee did not represent state aid. I will briefly refer to a few of them. We used an indicator from the Hinkley Point C decision by the Commission. As I said, it is imperfect. However, we do believe that it is comparable because the Commission had long negotiation with the beneficiary to bring this price to close to market level in order to ensure compatibility of the case. Moreover, what we believe that the price for, indeed, even if the price for this indicator had a different format than our price, we could convert it to a one-shot level. And what we believe is relevant is the annual commitment fee, which are underlined here, paid in the Hinkley Point C, and not the drawdown amount of 295 that the beneficiary will pay only if there is a drawdown. We have read that it's very unlikely that there are drawdowns under this price, so this is not the relevant price to compare. Furthermore, we found a set of qualitative indicators that show that why these two guarantee prices are comparable, and I will not get into the details. You have them in our report. Furthermore, what we believe, we were lucky to find a pretty close comparator, something that the same federation itself, which, as I said, is a very special entity, gave a few years ago to a company that is very similar to our beneficiary, because they are both essential infrastructure company. They have similar industry risk, which I show here in the bottom of my slide, that some of the financial indicators for the two industries are very similar. So we believe this is very highly comparable. Finally, another highly comparable benchmark, again imperfect, if I may say with all modesty, but highly comparable, is a domestic loan received by the same entity for exactly the same project in 2020. The fact that if it's given afterwards, actually, first of all, doesn't impact the leverage of the borrower, so the risk is the same because the amount is smaller than the initial loan. Moreover, we looked at the risk profile of the entity and of the country, and it hasn't changed in 2017. So for these reasons, we believe they are highly comparable. What is most important, and I wanted to tell in the 2 minutes that I'm left, is that actually Our main concern about this case is that Oxira, who we believe has the burden of proof on showing that that this constitutes state aid, brought forward two methodologies that are not that are ambiguous, provide ambiguous results, and this is not enough to show the existence of aid. In the first place, their first method, they estimate the cost of an unguaranteed loan to make the difference with the cost of our loan and compare with the price of the guarantee. We agree with this methodology. However, in order to benchmark the cost of this unguaranteed loan, we believe they made the wrong assumption. They took in the sample of the countries to compare countries that have a very different resistance towards coal. There are countries, as you can see here, where coal is going to be phased out pretty soon. So in these countries, an investment in coal doesn't make sense. We can even say it has an infinite risk. Nobody wants to invest into an industry that is going to be phased out by the country. For these reasons, we believe that the comparators are absolutely misplaced. Then from a more statistical point of view, we believe that the use of the average also leads to misleading results. The Commission prefers in all cases to use ranges because in an average can hide very different values. So the variation is not taken into account. And moreover, the sensitivity analysis we believe is incomplete, not least because it didn't show a worst case scenario. Finally, the second methodology of Oxira again relies on unverified assumption. By using the Commission loan margin, they made the difference between the risk of the entity and the risk of the borrower and the lender. But they assumed that the federation has the same risk as Bosnia and Herzegovina, and this is by no means verified. The federation has no credit rating, and there is no reason to assume furthermore that the beneficiary will have a lower equivalent to a company in financial difficulty. So for these reasons, we believe that the Oxira benchmarking is ambiguous and doesn't meet the standard of proof that is required to reach an uncontestable conclusion on the existence of aid. My final word is this, my final slide, that we call the Secretariat to finish the job. First of all, we believe our first line of defense was that there is no aid in this case. However, if the Secretariat doesn't agree with our assessment, they have to do a compatibility assessment. We, in our report this summer, showed that notwithstanding the fact that we believe this is no aid, should the Secretariat contest this, we demonstrated that this aid is compatible because it meets very important objectives of common interest: the reduction of emission and water consumption, a security of supply, both of electricity and of district heating in Bosnia, and all the other conditions of compatibility are met. Thank you very much, and I am here at your disposal to answer any questions you might have. Thank you.
Before I hand over to the rapporteur in this case, Professor Riley, I give you the information that both parties, of course, will have the possibility to reply to the pleas of the other party and also give closing remarks. So there will be the possibility for replies for both parties, of course. But before that, I would like to ask Professor Riley whether he has questions to both parties, and then the parties can also give answers to these questions. Professor Riley.
Yeah, thank you very much. I think I'd like to start actually with the Secretariat, if that's okay. The position, I understand it, with the first of the cumulative conditions, whether the borrower is not in financial difficulty. When I look at the Oxira report, it would suggest that, in fact, even if one takes a robust position, that in relation to some of the questions with the accounts, one ends up in a situation whereby one has very little alternative but to say that the conditions there are not satisfied. In other words, that the borrower probably isn't in financial difficulty. Perhaps you would like to clarify on that point. I realise there are a number of other issues here, but I'd just like to get some clarification on that as to whether or not I'm correct about the impact of the Oxera report on that point.
Sure. Thank you for the question.
Thank you. Are there any additional questions from other members of the advisory committee, starting with Professor Dustenberg, Vice President?
No, thank you, Mr. President. I have no questions.
If also the other members do not have additional questions, then I would like to ask the representatives of the Secretariat to answer to the question of Professor Riley.
Thank you. Thank you for the question. Possibility to clarify. First point, as you're aware, 4 cumulative conditions, so all 4 of them need to be fulfilled to be ejected from the to fall under the conditions of the Commission notice. Second point, what we did is a review of the Stated Council's decision, and therefore our submission in the recent request was that the assessment of the Stated Council is insofar incorrect as they did not assess all criteria of the restructuring and guidelines, and the ones it did assess, it did not assess properly because the data did not match the consolidated financial statements, and it did not take into account the comments by the auditors. As regards the conclusion, we have in our recent request also done the calculations with the data we have, but our submission is that the assessment undertaken by the Stated Council in its decision, which is the subject matter of the case, is incorrect because it did not assess all criteria and it did not assess the ones it did assess correctly. If that answers the question.
Okay, that's fine as far as it goes. But so the Oxera report on this issue, from what you're saying, does not support a position that even if you take account of the problems with the audited accounts, you still end up in a situation that there is a question there. And I understand what you're saying about that one cannot take account of it. I see what you're saying, but I'm just trying to get into the depths of the Oxera report here and the extent to which it may support the position of Bosnia-Herzegovina here.
I can confirm that the Oxera report looked into whether substantively the condition is fulfilled, whether it was at that point to be considered in financial difficulty, and it denied this.
Mm-hmm. Right, thank you. That's very helpful. Now, I'd like to move on, if I may, to Mr. Gecić, and I've got a question for him too, if that's okay. When I look at all of the different cumulative conditions, the most difficult one I see from the point of view of the contracting party here is the 80% of the outstanding loan condition, because at first sight it looks very difficult for you, because you have a situation where the entrustment has to be very precise in order to benefit from the exception, and it has to be only for a single service of the general economic interest and for no other economic activities, which it would appear to be the case that you have potentially several different services of general economic interest, other economic activities, and there's a question about the entrustment as well. So I would like observations on that point, if you have any. Thank you.
Thank you very much, Professor Riley. When it comes to the SGE exception, that's actually the key issue of applicability of law. As we mentioned, under Bosnia's rules, it's allowed to actually have more than one SGE, so to satisfy this condition. The question here is whether homogeneity applies or not. If homogeneity applies as a principle under the Energy Community Treaty, then the acquis and the Commission notice will directly apply. However, if homogeneity does not apply, as we strongly believe that it doesn't, based on everything that we showed in the explicit exemptions under the association agreement, which is, as I said, the primary source of European law, ratified treaty, a mixed treaty, and so forth, and where approximation is mandated in state aid cases under Article 70 of the association agreement, then Bosnia's secondary legislation applies. And under that legislation, this condition is satisfied.
Okay, thank you. That's very, very helpful.
Thank you.
Could we repeat that question?
Professor Riley, any additional questions?
No, I've got no additional questions.
Okay. Thank you very much. Now it's again the possibility for the Secretariat to either to give another replies and also to give their closing remarks. And the representatives of the Secretariat have 10 minutes.
Thank you very much. To be honest, we didn't hear much new here today from the Bosnian and Herzegovinian side. Especially, we didn't see any challenge on what is the real subject matter of the present case, and that is whether the State Aid Council's decision is flawed or it is not. Instead, we hear a lot of references to the Copenhagen economics report, to Oxera's report. And as we have said in the beginning, and as the representative of Copenhagen also mentioned, these are reports that have been commissioned and conducted post factum. That means in bringing these arguments here in the present proceedings, it's an attempt to improve the State Aid Council's decisions. 2 years later, and that's definitely not the purpose of this case, nor its subject matter. Instead, we heard a lot of more confusion here today. We hear, and some of them are really just raising fog-like reference to a principle of homogeneity, etc. We hear a constant confusion by Mr. Gecić of which law should be applied, and to apply European Union law in a case which is under energy community law and heard and decided ultimately by energy community institutions and bodies is evidently just not understandable. Also the procedure, I think it really needs to be very clear. We are here in an infringement procedure. It is evident from Article 90 of the Energy Community Treaty, which includes provisions such as Article 18, that the Energy Community Secretariat may bring infringement procedures, and they may be decided by the Ministerial Council. And in doing so, yes, this is not the way how the European Commission would do it under EU law, but that's because we are not in EU law. We are in a legal order that envisages that the Secretariat does not take any state aid decisions as the European Commission, DG Comp, would do, but it reviews state aid commissions taken by contracting authorities who are in charge of doing that in their internal legal order. And no, and by no means we would make a compatibility assessment. That is the State Aid Council, or would have been the State Aid Council's task, but it never got to this level. And finally, we also see Mr. Gecić here presenting new documents, which he presumably means as evidence. That's a bit hypocritical to reject our Oxera findings from yesterday, but to show here a confirmation by a bank. Again, that's too late, not only in this procedure where the written part stopped and the clock stopped ticking for written submissions on 26th of August 2020. It's also too late because we cannot ex post now try to improve the State Aid Council's findings and decision.
If I may continue with the arguments regarding the content of the State Aid Council's decision. First of all, I strongly object to Mrs. Claici's assertion that the other conditions, the second and the third, have not been contested. This is not correct. The ECS report only dealt with the first and the fourth because this was the task given to them. It does not mean that the second and the third were not contested. I will start with the third one because it was taken up by the rapporteur. And again, I have to say that Mr. Gecić did not provide any arguments regarding the conditions to fulfill the exception. The first condition is that there is a properly entrusted service of general economic interest. Bosnia and Herzegovina is obliged to transpose and implement Energy Community Acquis, which includes the Electricity Directive, and this directive requires any service of general economic interest to be subject to very strict conditions. A simple license by the regulatory authority cannot be considered a properly entrusted service of general economic interest. The other conditions have not even been mentioned or contested, namely that there can only be a single service of general economic interest, that there are no economic activities, and finally that the entrustment is done by the same authority. All those conditions are relevant because they are listed in the Commission notice. The Commission notice is also mentioned and applied by the State Aid Council. So the whole argumentation about non-applicability, homogeneity, and so on is irrelevant. Even the State Aid Council accepts the applicability and the relevance of the Commission notice in this case. Finally, I would just, because we still have some minutes left, although we were not intending to do so, because I repeat again, the subject matter is the State Aid Council's decision, which regarding the fourth condition only relies on a single benchmark, DBRD loan. This is why we address this single benchmark in our submission. However, I would just like to address what Mrs. Claici has said about the, in our view, irrelevant ex post assessment by Copenhagen Economics. As you can extensively read, the benchmarks used by Copenhagen Economics to show that the guarantee was remunerated at market price is flawed. First benchmark, Hinkley point. This is an annual fee compared to a one-off fee, so you need to multiply it. It is part of the wider aid package, which regards then compatibility. It did not control for several differences in the projects and the underlying finances, such as the credit rating. The second benchmark, the public guarantee of 2010. In 2010, Bosnia and Herzegovina did not even have state aid enforcement system, so we cannot use this level of remuneration to say this is market-based because it has not been checked. Nobody knows whether this was market level. Finally, the Damodaran benchmark. Where is it? It has been dropped. It has been criticized by Oxera because of inappropriate conceptual choices, outdated data, and it has not been taken up. Criticism has been recognized by Copenhagen Economics report on the 27th of November. And finally, the 2020 loan, which is not only ex post information in the sense of coming now after the 26th of August, but it is facts that only happened years after the decision of the State Aid Council. The State Aid Council could not even take it into account because it did not exist. And finally, also there we have huge differences which have not been taken into account in this parameter.
So to sum up, I think it is about time that we put this case back on its feet. And what it is, it's an infringement procedure concerning a decision by the State Aid Council of 2018. The defense tries to make us believe that the Secretariat DG competition style should have taken this decision with all the economic assessments, but in doing so, it actually just underlines and highlights the flaws of the State Aid Council decision, because that was the moment in time where such analysis should have been made. Thanks a lot.
Mr. Gecić, you have 10 minutes for your closing remarks.
Thank you kindly, Mr. President. As I can say, we strongly disagree with everything that you heard from the Secretariat. We think that this is that there is no case and that they've been for 2 years trying to prove something without any point. We strongly disagree with the comparison with DG Comp. We actually believe that if this was handled under the association agreement by DG Comp, it would have been done completely differently. And it would be done in accordance with EU association law, which was completely disregarded and even breached in this case by the Secretariat. On top of that, homogeneity we still believe is extremely important. We again refer to Ms. Kuhlmann's article where she says explicitly that homogeneity does not apply under Energy Community Treaty, explicitly that it does not apply, which on the other hand means that Bosnian regulations apply, and under Bosnian law, the SGIE exception is completely satisfied. That's why we didn't go into too much detail. The local state aid authority did that already quite amply. The references when it did make to the notice of the European Commission was done again completely in line with the association agreement and approximation rules where you can use Commission notices as interpretative instruments. That's again in accordance with Article 71 of the association agreement. When it comes to all of the questions of the credit rating and where you can again see a complete huge mistake by the Secretariat, there was no difference made with regard to the different entities in Bosnia. I think that in Europe, even birds know that Bosnia is a highly complex country under a very complex constitutional mechanism. This year, it's 25 years of the Dayton Peace Accord that actually brought in that constitution. We have entities in Bosnia that have completely different credit ratings, and the federation that doesn't even have a credit rating, while the whole state has a different credit rating than, for example, Republika Srpska, which is another entity. This was totally disregarded in the entire critique of the case. When it comes to other issues, I mean, the Secretariat is mentioning the transposition of a directive. I fully agree, but that's the question of timing. If it wasn't transposed, then it isn't law and it cannot apply retroactively. When it comes to all of the assessments that have been done in the meantime, they have been done based on contemporary, meaning 2018 facts, not now. And this is completely in line with ECJ case law. Finally, and this is also extremely important to underline, we've received, the same way that the Secretariat has been providing new evidence, Raiffeisen Bank is a very reputable Austrian bank and their processes take a lot of time. So unfortunately, it took months to get this certificate from them, but we have a bank, a highly reputable foreign bank, an Austrian bank, certifying that this guarantee was on market terms. And this is the truth, meaning that the outcome, the final decision, the operative part of the decision of the state aid authority in Bosnia would and doesn't need to be changed. The Secretariat has every right to not be happy with the reasoning. If it's so important to do a case for 2 years just to change a reasoning of a decision, I applaud the Secretariat for the efforts, but frankly, the outcome would be exactly the same, and we have a highly reputable bank saying so. On this point, I would invite Ms. Adina Claici if she has anything to add.
Thank you. Thank you for all the previous comments. I only wanted to underline or to reply to the comment on the ex post report. In the practice of the European Commission, all the analyses are done ex post. However, that That's why in the notice of the notion of aid and all the decision of the Commission is highly stressed. They are valid to the extent that they are relying on contemporaneous information. So I sorry to repeat, but I think this is very, very important. We don't come here to improve the decision of the State Aid Council. That was claimed by the Secretariat. We don't come here to improve this decision. We just come here to support this decision, to bring evidence that this decision was correct. If we were there to advise them, we would have said in 2018, look, we have various benchmarks here to show, and we would have asked the bank as well at that time to show. The council, the State Aid Council, didn't consider necessary. They took other ways to prove it. We don't want to improve their analysis. We just want to support it, to say that it's valid and this is no state aid. And I very much welcome the discussion on substance with the auxiliary representatives, and that is why we dropped one of the initial benchmarks. In all honesty, we did say none of the benchmarks is perfect. We tried to establish a range. One of the benchmark did not stand to the high standard of scrutiny that we would have liked of CIRA. Therefore, we stayed with the three others, which we believe are very, very strong and very comparable. I'm asking for common sense here from the advisory committee, because we are talking about. We brought lots of qualitative indicators to show that our benchmarks or our comparisons go in the right direction. They are not perfect. We didn't make an average of our three comparators, because we wanted to provide a range. If you look at all the Commission decisions, for example, PACS-2 investment into nuclear power plant, I was back then at the DG competition and I was working from the Commission on that side. We established there from the Commission ranges of confidence. We don't go to do averages because there may be a variation. So we established a range of 3 indicators that are highly comparable. None of them is perfect. They are highly comparable. And on top, we have the proof from the market saying, look, this is a market benchmark. It is very difficult in the Federation of Bosnia, not even the country of Bosnia. For the Federation, if you go to financial advisors, you find very little information. It's very difficult to find something perfect. And that's why we also criticize CIRA for comparing with countries like Sweden or all these green countries. You can't compare countries where coal is the only source of electricity in the country in the coming 20 years with countries that decided to go green. So therefore, I'm asking for common sense to take into account our benchmarks as imperfect comparators, establishing a range that gives the sufficient confidence to say that the initial State Aid Council decision was correct, and this is no state aid. And as regards the compatibility, as the Secretariat might know, we worked in a previous case in Serbia 2 years ago, and actually that case was closed on compatibility grounds. So to my limited understanding, there should be some consistency with past practice. So why not accept a case on compatibility grounds, given that there are strong reasons for compatibility? And yes, thank you very much again.
I would like to thank the representatives of both parties for their pleas and also closing remarks, also for staying within the set time frame. Now, for the minutes, I would like to ask the representatives who showed the slides to send us the slides. That's for the minutes. The advisory committee will deliver its opinion at a later date. It will be a written opinion, which will be sent to the parties. And at this stage, I will close this public hearing, and thank you for attending. Thank you. All the best.
Thank you.
Thank you.
Have a good day.
Thank you. Goodbye.
Bye.
Thank you. Goodbye.